Okay, ladies and gentlemen, good morning, everybody. Thank you to attend this press conference. As you are aware, since Wednesday morning, in fact, Tuesday evening, we, high-level group delegation, came from Luxembourg to visit Latvia and to have a lot of visits with several stakeholders in the country. The issue was to focus on the beneficial impact of EU law, highlight in its direct effect on the member states, and how to increase all possible cooperation and exchange with the Court of Justice in Luxembourg and institution here in Latvia. I will now give the floor to Ms. Ziemele and then to Ms. Reine. Your judges, if I may say like that, even if they are European judges. And after that, to Mr. Alfredo Calot Escobar, the Registrar, they will give you, I think, a valuable overview of the exchange with Latvian authorities. And then we will give you the floor to raise questions. Ms. Ziemele.
Thank you. Thank you, Juan Carlos. Labdien.
Good morning, dear colleagues. I already know you. Indeed, as my colleague, Mr. Alvarez, just said, the delegation of the Court of Justice of the European Union comprised of me as the judge of the court and Inga as the judge of the General Court of the European Union, Mr. Alfredo Calot Escobar, who is Registrar of the Court of Justice, and also heads, directors of main directorates and director generals. A delegation of this kind, until now, in the history of the Court of Justice, has never flown anywhere. This is the first project of the kind, and it is implemented in Latvia. Why in Latvia? I also have to say that Ms. Reine is in the General Court since 2016, but also when I joined the court more than 2.5 years ago, I understood that, of course, the Court of Justice and its case law, which has an impact upon the daily life of Latvian citizens as the citizens of the EU, be it matters of transport or banking or money laundering or competition or rural support. The work done by the Court of Justice and the judgments should be brought closer to the citizen of the EU. And upon understanding this, I started thinking about this, and it turned out that the head of our court's administration also had the same idea already for some time about sharing of information, communicating. So Luxembourg, Latvia, and Spain met somewhere in between our offices. And that's why we have this pilot project. Indeed, in the 21st century, as you in Latvia have already become used to this, and I can claim some responsibility for it. The Supreme Courts go to society and explain their judgments in different forms. And it's normal, and it's a good thing, and we see the same understanding of courts communication at the Court of Justice of the European Union and at the European Court of Human Rights. And that's why we are here in this composition. It's an unusual composition because usually judges come to speak to their colleagues, other judges, or they go and visit you. This is all. we have already become used to this, but this composition is broader, also covering some technical functionalities of the court. This is really happening for the first time. And I'm indeed very happy about this, and I feel grateful to my colleagues. I would like to express my gratitude to the head of administration, to Mr. Carlos Escobar, and to all members of the delegation for being here and for having those very valuable meetings with representatives of 3 branches of power in Latvia. As regards executive power, we met Ministry of Justice and Ministry of Education. And Ministry of Education is also very important. So for us to be equal players in the European Union, we were speaking about the rule of law and understanding of it in the Latvian legal space and making it comprehensible to Latvian citizens. As I said, we visited the President of the State, the Parliament, the Ministry of Justice, the Ministry of Education, and of course we visited the Supreme Court and the Constitutional Court, and we also had a meeting held here at the at the EU House, where we have this cooperation with the Parliament and the Commission and other EU institutions. And this entire day has been dedicated to conversations with you, esteemed journalists. We have spoken a lot about court rulings. We have spoken about the way the court is functioning, the way the court is providing support to judges. We have been speaking about Luxembourg business register case. If anyone is interested, we have been discussing the case of private institutions of higher education. We have been speaking about the sanctions and energy, everything that both courts are involved in. And of course, if you have any questions, we will take them. But at this point, only about this idea and the philosophy behind it, what we were doing here and why. So I think I have already explained this, and now I give the floor to Mr. Reine. Thank you. Indeed. I'm very happy that we share the thoughts about communication on national level, and that we have seen these ideas implemented in this project. Of course, we travel a lot and we communicate with our colleagues, but this is now on a slightly more formal or official level. And so the main lessons from this visit, and at least the way I see it personally, and I also see this as a good task for the future. We have been in the EU for almost 20 years. Next year, we are going to celebrate 20 years of accession to the EU. We have spent almost 20 years within the EU, and we still live in a reality that we have understood it this way, that the EU is a very complicated political debate, but we still, to a large extent, perceive the EU as being over there and us being here. And the lesson from this visit really is confirmation of this rather sad thesis, this whole attitude, us and them. And I also see a quite wrong understanding of the legal remedies that are accessible in the EU, because we are 2 judicial institutions on the EU level, which are accessible both directly to individuals. I'm speaking about the General Court of the EU, and also as a dialogue between the national courts and the Court of Justice of the EU. But unfortunately, in Latvia, we see that this understanding is still quite low. We have a narrow community of professionals who understand the differences. However, if we speak about broader understanding, I see it as missing. And this means that inhabitants of Latvia are continually living with certain lack of information, absence of information. I'm not speaking about ordinary people on the streets. I'm speaking also about politicians and specialists who do not understand these mechanisms. Of course, it's important to have political debate. It's the beginning. But the EU legal regulation is quite extensive, and that's why we have legal remedies related to this. And the end of this story is that somehow it has been lost. The story about the accessible legal remedies. It had been shelved for 20 years. So it's a good lesson for us and also lesson for our colleagues who work at Latvian authorities as well. We should think about ways of improving this situation. Because we not only ensure that Latvia is a state governed by the rule of law within its internal bubble, if I may say so, but it should also be a rule-governed state in its relations with the EU. And I think that we could still work on this because it's a very important matter. It affects the daily life of Latvia's inhabitants, and also we know that the goods and services, it affects the goods and services that we use on a daily basis. It affects the competitiveness of our companies and the state aid provided to our companies. And I believe that we should improve and expand understanding of this because I saw it as missing.
Reine, Mr. Alfredo Calot Escobar.
Thank you very much. It's a pleasure to be with you today. It has been a pleasure to be in Latvia since last Tuesday. As Judge Ziemele mentioned, this is a first experience. Of course, judges, advocate general, they explain this part of the job, I would say, to explain the importance of the European Union, the functioning, the rules. In each time they have the possibility to talk to the citizens, to the stakeholders. What is a little bit unusual is to have the administration of the institution that are trying to produce information, communication tools, research tools, multilingualism, to come to the member state to talk to the people who are using these tools and to ask them how we are doing. Are you satisfied what we give to you? Do you need something else? Do you need something different? How can we cooperate? No more, no less. This was extremely important to do, and this has been done in Latvia. And, well, we were really honored to be received by the President of the Republic, of course, and we had the possibility to address to the members of the Parliament, of the Saima, and it's important for the deputies or the members of the Parliament to be informed, of course, of European Union matters. Then we have, of course, a discussion with the colleagues of the Supreme Court and Constitutional Court, and this was very important also from a technical point of view, from administration point of view, the staff. What research tools do you need? How are they using that? How do you perceive? It was really wonderful discussions. And then I would mention the discussions with the Ministry of Education and the Ministry of Justice. And this was especially relevant, I think. The Ministry of Education, because in this discussion, we agreed that there were two essential aspects that we should work on. The first one is the language education. It is important to develop the language knowing of citizens in Latvia and abroad. And of course, we are talking about English, but not only about English, because languages are a key to understanding the culture and the personality of the other citizens of the other member states. It's an essential part of it. It's an essential part of the European Union. And second, learning the European Union matters from the beginning. It's important that young children, the youngsters, they know that they belong to a European community, that they know their rights, that they can develop as informed adults to take a stand concerning European matters. This is necessary to develop, and it was clear in the discussions with the Ministry of Education that there is the will to do it, and as far as we can help the Ministry of Education, we will do it with unlimited resources. And then the Ministry of Justice. And it was clear that it is necessary to develop also the tools to inform Latvian judges and fully European judges to know EU law and EU jurisprudence. We must make these tools easier to use. That is absolutely clear. And we must try to find a way to give Latvian judges the possibility to even come to us, to the Court of Justice, to spend some time with us, because they are, it depends on national judges, the whole functioning of EU law. So this was also important, and I will mention also the meeting, of course, with the responsibilities of this House, the House of Europe, where you have had since 2010 the information, all the information concerning basically the European Parliament, the European Commission, and the European Union in general, of course. Now we are going to be a part of it. There will be a stand with information of the Court of Justice where any Latvian citizen can come here and get the information it wants. There are plenty of ideas, many food for thought, and we will coming back to Luxembourg to keep on working with the Latvian authorities. We will keep on, if I may say so, using you as a pilot test of how we can work better with the citizens of an important member state. You are at the heart of Europe, now much than ever, with what's happening, obviously, unfortunately, very close to here. And you are going to celebrate 20 years of accession to Latvia very soon, and this is going to be, from my point of view, if I may say so also, an excellent opportunity to recall the Latvian citizens the importance of being a part of it, of being a part of the European Union. Thank you.
Paldies, Mr. Alfredo Escobar. No, I will give the floor to you. I will ask that you identify yourself, which media you're working for, and to whom you want to ask the question. Katia, if you can raise your hands. Yep.
Answers Bogustovs, and I would like to ask both justices. I know that you can comment the cases that have been adjudicated only, but I just wanted to understand, in principle, has anyone asked you regarding the restitution? Has anyone made an application to the court with the frozen oligarch assets that nobody knows how to transfer or channel into Ukraine and what to do with it? Have you in any way dealt with this? You know, has there been any legal position formulated by the CJEU, or do you have any applications, any cases pending? Would you foresee any such cases, or are you really not qualified? Do you have jurisdiction over these cases? Do we have any other courts who would have it in their jurisdiction? Should it be the jurisdiction of the special ad hoc tribunal to hold Russian regime responsible for the war crimes accountable? And what about the resources, the legal resources, the funding? And what about the urgency in case of Ukraine? How are you going to deal with that? Because it's something that we have to do now, not some years later. So that's question one. And I would also like to hear a similar answer from you about a case here in Latvia. For 1.5 years, the war has been going on, and we have still emergency state that is being constantly carried over because of the war, and there is a potential threat of Russia attacking, and the same state of emergency has been invoked by Poland. And whenever this state of emergency is declared, there is a reference to pushbacks, as they are called in English, to push back any forces from the European Union territory to be able, or rather, the push back the border. So, what about those border regions? By invoking a state of emergency, you basically suspend any international laws or rights for this time, and it's been extended by the Latvian state for another 6 months, if I'm not mistaken. So, is it acceptable that a country where no military activity is taking place, is it normal to have a state of emergency in some regional areas? In our case, it's some of the regions along the eastern border. So I know that you might not have all the legal information available to you right now to answer this question. I apologize for, digressing from the main subject, but nevertheless would like to hear your opinion on this. Yes, sir. Thank you. These are two, indeed, political and legal dilemmas that you are raising or interested in, and it is only natural that right now, on the spot, as a delegation of the CJEU, we cannot really comment on the political side of the matter. We can give you some legal advice as regards to the frozen assets held by Russian oligarchs and other citizens and their seizing. Well, that depends on a political decision. The political negotiations are ongoing. How will that affect the courts? It's yet to see. Whenever it is presented before us, we will use all the legal arsenal, and Madam Reine can elaborate on that, to deal with any individual, any legal or natural entity whose interests might be affected by such decisions, because we already have several questions about this, and I'll give the floor to Madam Reine after me to comment on that. So whatever legislature at the European Union level will decide, it is of course imperative to ensure that European courts, in scope of their competence, ensure the rule of law. That's my answer. As regards to those border areas, well, let me give you a comparison, and a partial comparison. My chamber made a ruling last summer in the case, or in the case of the preliminary request from the Lithuanian Administrative Court. It was the case about, again, one of the border areas in Lithuania, and about the invoking of the state of emergency. And if I'm not mistaken, one of the Iraqi national, despite the state of emergency, of course, illegally crossed the border and entered Lithuania, was found or detained in one of the Lithuanian towns, according to Lithuanian legislation with regard to border management. This citizen, this national, did not have any rights to apply to any court or any institution. So that's because the state of emergency was invoked. But you have to, always check what it means in every particular case. In Lithuania, there was no in fact, legal grounds for him to apply for any kind of alternative status or asylum because of the state of emergency, and CJEU interpreted the Union legal acts with regard to asylum seekers and asylum applications within the EU, because it's not, about Latvia or Lithuania per se. It's about the whole Union. So it referred to this regulation, and we basically made the same reference. So once they have entered the jurisdiction of the European Union member state, they should be able to enjoy full rights and apply for the asylum and explain their case. And each case needs to be assessed on case-by-case basis, because situations may differ. He might be, or this person might be a victim of human trafficking. They have been probably smuggled into Lithuania or Vilnius, so that might also be the case. So we should get the Citizenship and Migration Agency involved, and hopefully, they can check the documents that are hopefully submitted or provided in good faith, have precise data, and then it can then resolve the status of this person. And this is the explanation that we gave in this Lithuanian case. Whether the state of emergency had anything to do with this, because the Lithuanian government actually justifiably also referred to the national security, and they, explained their position from the beginning to the end, and we well know what the situation is here in Latvia. So CJEU didn't have any problems with the legitimacy of the rejection, because such a restriction of rights is, of course, acceptable under special circumstances. But if, for example, somebody would ask for help, they are entitled to receive this help from institutions. They shouldn't be denied or rejected. That is the case law, the existing case law, to the extent to which this case law applies to similar cases in case of Latvia. Nobody has asked us about these questions or raised these issues. Maybe they are not on the official radars, on the formal radars. Maybe they are not on the radar of the courts, but we'll see.
Just to add to what was said concerning this debate, it clearly outlines the absence of information, especially with respect to interaction between situation in the EU and the member states. And this example of Lithuania is quite good. And here we have two elements: the emergency situation, state of emergency as such, and the effect that this situation projects upon individuals. And in both cases, of course, we have to ask to what extent it's compatible with EU law. And if we look at this situation in general, of course, in some cases, a national judge could verify the situation or review the situation per se. But since this situation directly impacts the safeguards for individuals that have been enshrined in the EU law, so really we have this question how compatible the national situation is with the EU law in general. And we also have to speak about the competence of the European Commission to perform certain oversight over such situations. And of course, there are some specific cases, irrespectively of whether the situation is compatible or is incompatible. There are specific cases that have to be reviewed by a judge. And irrespectively of whether the general situation is legal or not, and whether this resolution, and then we have to look at the impact upon the individual and compatibility of this. And of course, the Commission would have to respond to complaints, and decisions should be appealed before us. We have control over the Commission's decisions. But if the Commission starts an infringement procedure, then again we have the legal remedy provided by the Court of Justice when reviewing the dispute. And the third point, that possibility, as in the case of Lithuania, an individual through the national court clarifies his or her rights. So these are the mechanisms that we have been discussing a lot. And actually, your question is very pertinent. This is really the gist of the matter. So that all people understand that something is wrong in this discussion, something is not quite clear, but how to clarify, how to understand what should be done. Here we see really this absence of information. And now, speaking about seizures and confiscation of assets, this is a very hard topic, also pertaining to the conflict in Ukraine. Of course, the political discussions and debates are very difficult, are very hard, because the opinions of 27 member states have to be harmonized, and a decision on joint effort should be taken. But let's remember that the EU already within almost 6 months, what has been done, member states, in order to start this discussion at all, have opened the treaties of the European Union and have now defined this competence for the EU to examine such infringements that stem from restrictive measures. And so we have these two proposals to criminalize evasion or infringement of sanctions, and accordingly a related proposal on seizing and confiscating assets. This is legally and politically a very complicated matter, but a lot has been done, and we hope that even more will be done. But really, we have to see what kind of jurisdiction will be defined for both the courts. But it's quite clear, whatever regulation is adopted, rather minute legal oversight will be ensured. The mic is not really on. Oh, thank you. We are now speaking about information, what we receive about the court, and also matters interpreted by the Constitutional Court, by you and also Madam Osipova. We have received very extensive explanations and interpretation, and this will really be helpful in our work. But my question, it relates to your visit of today, and but how this situation has been noticed, that the judgment by the Constitutional Court has not been implemented by the politicians. And I believe that the prestige of the courts is undermined by politicians' attitude, like showing disrespect to the court. Have you noticed it? Or is it really one of the hidden objectives of this visit, to deal with this case somehow? And do you see any solution to this? Thank you. Actually, I've been lucky enough, and I can combine experience gained from 3 courts. So, first of all, as part of our working visit, this was the aim, and the objective was not related to the problems that exist or existed in communication between the legislator and the Constitutional Court. Our visit is not related to this. As we all present here have said, what we see, it's important to show how the EU law functions and what kind of legal remedies we have. And we still have not mastered this in Latvia during these 20 years. And this is the primary aim. And actually, the EU law has greater impact upon us, even compared to the European Convention on Human Rights. There's impact on our daily life, on copyright protection, which links to your jobs. So we are all within this EU legal regulation. And it's quite even dangerous not knowing how it functions and how to use it. So this is the main and only function of this visit. But now, as regards the judgment by the enforcement of the Constitutional Court's judgments. And these judgments are addressed to the legislator. Perhaps I might give comparison to you. Perhaps you know, perhaps you have followed the case laws that we have related to processes in Poland. And we have come to the conclusions, but this pertains not only to Poland. So our conclusion has been that the independence of the judicial power has been threatened by decisions made by the legislator and different other organizations, at least 12 judgments in the Court of Justice. The European Union cannot function if it is not based upon independent national judges. The Union depends upon it. As Mr. Escobar said, national judges are the first ones and primarily the ones who apply the EU law. We support, we assist, but the EU will just not happen if we see independence of judicial power being undermined. And we know that enforcement of judgments is one of the central elements of the independence of judicial power. And if this is initiated as a case, it might end up at the Court of Justice. Perhaps a court could suspend legal proceedings and refer a question regarding composition of a court, or it's not directly linked to the context that you were referring to. But I'm just saying that the whole matter of the independence of the judicial power comes into the focus of the Court of Justice. And the Commission, as Ms. Reine already mentioned, has the right to initiate infringement procedure against any member state for failure to abide by the treaties of the European Union. And the rule of law, it's then Article 19, Article 2, and also independence of the judicial power is one of the central elements in the treaties of the EU. Infringement procedures have been initiated against our neighbor who is not so far away from us, and then it ends with the Court of Justice. And finally, it can also, the outcome might be payment of huge damages. And in another context, I believe this is the second time for Latvia when infringement procedure has been initiated. And this infringement procedure is linked to invasive species, to this regulation of the EU. And the Commission in general supervises the rule of law in the EU and has to follow how the countries are abiding by the treaties and secondary legal acts. And if this dialogue fails with a member state, then the Commission has the right to initiate infringement procedure. And this is really the final method, the final solution to this. And these infringement procedures have been initiated in particular in the area of environment. But it would be better to avoid them because the EU presumes that all member states that have been able to accede to the EU after meeting the criteria, that these states have reached a certain culture of rule of law. And so and the rule of law should be able to function in these countries without analyzing specifically what has been enforced and what exactly has been enforced from this judgment, although I have done it at another event. But if you look at it, how it looks like in the framework of the EU, just for you to know that this is being monitored, and there are also legal solutions to this, coming back to what Ms. Reine just said.
Judge Ziemele, another question, the last one maybe? Yep.
Labdien, this is Mara.
I am Mara Libeka. I represent the largest newspaper in Latvia, Latvia's Avīze. Some time ago, sanctions were lifted that were imposed upon Yanukovych. And also Abramovich and other friends of the Kremlin have turned to the court. What was the reason? Was it because the state of Ukraine did not have sufficiently powerful lawyers? And my second question is, does the Court of Justice accept all the questions for preliminary rulings that are sent to it? Now, for example, we have these legal proceedings involving former president of the Bank of Latvia. And the question arose regarding his immunity. It could have been clarified in a very short period of time, but this question was referred for preliminary ruling, and we were waiting and waiting and waiting. Do you really have to admit all those questions that are referred to you? I will answer regarding the sanctions, and I will leave the matter of preliminary ruling to Ms. Ziemele. Currently, in connection with Russia's aggression in Ukraine, we will not be now speaking about sanctions of 2014 related to annexation of Crimea, but only looking at the recent situation. We currently have approximately 75 applications submitted because all those restrictive measures by the EU, the decisions are adopted on the EU level, so these decisions have to be reviewed by the General Court. Most probably you have heard about the case Russia Today. This is one of the cases that we reviewed in, well, it was accelerated procedure. We examined it within 6 months, and we have delivered the judgment, but cassation appeal was submitted, so we have to wait for the final ruling by the Court of Justice. And regarding those persons, natural and legal, who are on the sanction list, they are very actively appealing against these decisions, because clearly for these people and these companies, actually, we see that sanctions, it proves the effectiveness of sanctions, because people are appealing so much. These are restrictions on providing services, on traveling, on obtaining visas, also seizing assets in banks. And as we know, for some people, their vehicles are very important, like yachts and so on. So apparently they experience certain difficulties and certain discomfort in moving across the borders. Yes, we are reviewing these cases, and we are doing this in a very meticulous way. As regards Mr. Yanukovych, the Ukrainian government, it did not involve lawyers of the Ukrainian government. This was a decision by the EU, and in this case, this decision is defended by the lawyers of the EU. And here we had a very interesting situation. In the case of Mr. Yanukovych, I believe this was already the second or the third extension, and we found in the court that the case file, the case materials, indeed, we performed very accurate review. like, for example, an administrative court in Latvia might look at the case file and see that the case file does not comprise the information that would justify this decision. This decision, we might, perhaps this is really separated from our own belief. We have to perform very strict legal review, because we have to do this work in high quality. And in this case, the Council did not do its job properly. Facts were not verified. And so we have to invalidate the decision, whatever we would think about the particular person. But of course, this information comes into the Council from member states, and this is a very strong signal that we are giving to the member states. They have to do their job properly. They have to do their homework properly. The EU is a union that is governed by the rule of law, not only because the member states have to be democratic and obey the rule of law, but also the institutions, and we cannot allow institutions functioning in arbitrary way. Of course, I cannot speak here on behalf of Latvian institutions, but what we see now in relation to sanctions now, in the context of Russia's aggression. For the first time in history, indeed, in the case of Russia today, member states had become involved. Latvia was one of the participating member states, and the Commission and also the High Representative of the in foreign affairs. And actually, this clearly showed that we have come to a new understanding of the importance of these cases and how important it is for the member states to do their job properly when collecting this information and explaining some aspects of the decision in this process of judicial review. We have some other interesting examples related to those recent sanctions. Russia's aggression in Ukraine also made the EU to propose or to invent new categories of sanctions. Never before we have imposed sanctions upon media. Russia today is a media outlet. In the case of Kisilyov, that was a fictitious journalist who could not be considered as being a journalist. But Russia today formally is a media, and it's a special case. We have to understand by cutting out the cancer, we should not kill the patient. We should not create a precedent that would bring adverse consequences to other media. And so, of course, now we have to think about third parties in those cases. One of the restrictions that the EU has imposed is prohibition to provide legal services to Russian companies operating within the EU. The political aim is clear, but now we have to review the legal solution to this. These are very interesting cases, and maybe that's why it's an explanation also why we sometimes invalidate a decision, although we personally might believe that the person deserved it. We really separate this procedure from our own beliefs.
And of course, those cases, and your question about Mr. Rimshevich, the former governor of the central bank, if there is a court ruling in cases when people's rights have been restricted, these rulings can be appealed against, and we are the court of appeal that makes sure whether the general court has taken into account all the circumstances of the case when making the ruling. Now, as regards to the other ruling in the case of Mr. Rimšēvić with regard to his immunity as the ECB board member. Well, it's not as straightforward as it may seem. It is a very complex legal issue. Not all the highest EU officials who enjoy immunity, guaranteed immunity, are being detained, are being suspected of rather severe offences, severe crimes. It happens very rarely in the European Union, and his lawyers, Mr. Rimšēvić's lawyers in the Latvian court, announced that he's an EU official enjoying immunity granted to him as the member of the ECB board, and the accusations or the charges pressed against him concern his official duties. Therefore, as an EU official, he should be granted the immunity, and that's what the lawyers claimed. And the Latvian judge analyzed the EU immunity rules, and there was no case law to base your decision on. This was the first case of this kind. The Mr. Rimšēvić case is the unfortunate contribution of Latvia to the development of the legal practices in the European Union, because the court had to decide where's the limit of the immunity and where this immunity no longer apply. And also this judgment, just as you said, Madam Liebecker, the judgment didn't clearly say to which proceeding this applies, whether he has the immunity or not. They could have probably called, but it was not clear how procedurally you should clarify this. Should the prosecutors call the European Central Bank administration to find out about the immunity, where to go? And this was in particular addressed in the second ruling in the Rimšēvić case, and then National Court could proceed with other accusations. You said it took a long time to establish his immunity, but in general, on average, the maximum length of prejudicial ruling is 17 months. You have to take into account that all of this has to be translated into 24 official languages of the court, and when the ruling was announced, when all the documents were interpreted, everyone had presented their facts, had provided their statements, the debate has completed, and everything has been translated, all the documents, because the case language was Latvian. For me, it was therefore easier to work with all the documents, but other judges had to work with the translation of the documents into French. And when the ruling was made, the ruling had to be translated from French into Latvian and then into all the other 23, or rather 22 official languages, because it was a Grand Chamber ruling, because this was a case law binding for the Union as a whole, for the whole European Union. So with all the languages, with all the multilingualism, with all the legal research, because it was very important to analyze international law in this case, the ruling at the end of the day was very, very well weighed compared to other cases. I believe we were extremely expedient with this ruling. I don't think we could have done it faster, but I don't know what happened next in Latvia, because it was, what, a couple of years ago that we made the ruling in the CJEU?
Judge Ziemele, we are coming to an end. It's practically 1 o'clock. I want to thank all of you to attend this press conference. Just thanks, obviously, the participants, Judge Ziemele, Judge Reine, and Registrar Alfredo, Calot, Escobar. I have also to thank the Latvian portals and Registrar for the web streaming of the press conference. Draw your attention, we mentioned several case law cases. They are all on the website. Try to explain to you, Courier website, courier.europa.eu, if you want more background. And thank you all the participants to this event. Paldies.
Thank you. Paldies.